from 11 to 12.
Hello there, Tampa. This is former NFL and college football coach Jimmy Johnson. Listen to the Kelly Show every Monday starting at 5 p.m. They can sure use the attention.
And this is former Major League Baseball player, Hall of Famer Wade Boggs. I also hope you listen to the Kelly Show every Monday starting at 5 p.m. They can darn sure use the money.
Hi there. This is marine wildlife artist and conservationist Dr. Guy Harvey. Please listen to the Kelly Show every Monday starting at 5 p.m. They need to feel worthy.
Tampa Bay's TAN Talk. Entertaining and informative radio for the Sunshine State.
It's time for FLA Law, brought to you by the personal injury attorneys of Perinick, Caulfield, Averill, and Noyes. This hour will be informative, along with taking your questions and comments. Now, here are your hosts for today's show.
That's right. We are back here with FLA Law in the studio at WTAN. We are here with our legal live call-in talk show that we do every Tuesday at 5 o'clock. And I am here with a special guest tonight. But before I get into introducing who she is and how we know her, I am, of course, going to give you the rundown on how to listen in, how to call in, how to get your questions in tonight. So, of course, we are Perinick, Caulfield, Averill, and Noyes. We're injury lawyers here in the Tampa Bay area. Our main office is in Clearwater, and we are broadcasting live from the Clearwater studio. But, of course, we handle cases all over the Tampa Bay area and the state of Florida. And so, of course, our listeners out there, we do want you to call in with any legal questions you have tonight. Of course, we specialize in personal injury, but we can also take a stab at whatever questions you might have, or, of course, try to point you in the right direction. So the call-in number for tonight is going to be 727-441-3000. Again, that's 727-441-3000. As our regular listeners may know, and for anybody that's new, my name is Jacqueline Bryant. I am one of the personal injury lawyers at Perinick, Caulfield, Averill, and Noyes. I told you I wouldn't be here this week, but here I am. You couldn't get rid of me that easily. But for good reason. Matt, who was going to be hosting tonight, my partner Matthew Noyes, is actually going down to Fort Myers to support his son. They are in the regionals, I believe it is, like a championship of some kind, and they're doing well. So they have a game tonight. So good luck to CCC and Jacob. Hope you guys win. I think they tend to win when we give them good luck on the air. So let's hope that continues to work. But anyway, so that is what that is why I'm here, and I sound a little stuffy. I do apologize. I probably don't always sound that great on the air anyway. Now, on top of that, we've got a little bit of a cold brewing, so please forgive my stuffy voice, but my guest is probably going to do a little bit more talking than me, we hope, so you don't have to hear my voice. So with that being said, I want to also let you know where we're streaming on socials tonight. We are also going to be streaming live. Looks like we had a viewer on Facebook. Hello, whoever's out there watching, please share, like, comment, leave your questions in the chat box. If you don't want to call into the station, you can actually leave your comments right here on the live feed, and we will answer them live on the air. I can see them as they come in, so Lori and I will get to answer those for you. We are also live on YouTube. So what I want to do is tell you how to find us. If you're on Facebook and you want to check out our live feed right now and see us in the studio, hi, Facebook land. The Facebook page is Perinick, Caulfield, Averill, and Noyes Injury Lawyers. And Perinick is spelled P-E-R-E-N-I-C-H. Perinick, Caulfield, Averill, Noyes Injury Lawyers. That's how you find our Facebook page, and we are live right now on that page. Now, if you are on YouTube, you can find us the same way. Perinick, Caulfield, Averill, Noyes Injury Lawyers. Look us up on YouTube, and you will find our live YouTube channel as well, and you can leave the comments there. Unfortunately, I can't see your YouTube comments as they're coming in tonight, but we will go back and answer any questions you have left in the comment chat. We'll answer those later. So definitely go ahead and still leave your comments on YouTube, and we will answer those or respond within the next day or two. So with that being said, let's talk about who we have with us tonight. I could sit here and give you a spiel about her, but I would much rather her tell us about who she is and what she does at our firm.
Great. Well, I'm so excited, Jacqueline, to join you tonight, especially because here we are on FLA Law. So I've been with the firm for, it's hard to imagine, it's been coming on 25 years.
Oh my goodness, yeah.
But even more hard to imagine is that I've been practicing law for 44 years. Oh my gosh.
Time flies when you're having fun.
We ladies don't like to admit these things, but actually, I'm so grateful, and I love being with Pernick Caulfield, Averill, and Noyes. As you know, Matt and I work as a team.
Exactly.
And we've worked closely together for most of my time there at Pernick Caulfield, Averill, and Noyes. And when I started, it was so fun because it was a little different in the TV world then, and they actually had a TV call-in show that was
Exactly.
FLA Law.
Yeah.
And it was a lot of fun. We did it. Gosh, I can't even remember whether it might have been once a week. It probably was, or I think it was. Yes,
I think so, or
so.
Maybe even was it every day? It couldn't have been every day.
I don't think it was every day, but I do. And we had a studio.
I know it was much more frequently than what we do now.
Now, my favorite was as you know, I love puppy dogs. So my favorite, we actually had one I actually hosted where we would bring in guests from the community, and we
Sure.
hosted a program for the SPCA and other groups that work with animals.
Right.
So we had a bunch of pets come in. Some Kim Pernick brought
on a TV show.
Yeah,
That's
yes,
cute.
she had her little min pin, and I had a buff cocker, Maggie, and other lawyers that were sharing. It was a lot of fun,
Right.
So and then we talked a little bit about law that might relate to those issues. But
you got to tie the law in somewhere.
Exactly. But we have fun. And so I am primarily involved in the litigation, as you know, on Matt's team, and was fortunate when I came to the firm to be able to really try a lot of cases and become board certified in civil trial.
Right.
And so it's something I enjoy very much. Fortunately, most people are happy to know that if they have a case, they probably won't have to go all the way to a jury trial. And of course, you'd never have to if you didn't choose to.
Right.
Most cases can be resolved without that. But it is very important to be able to try the case well and successfully. I know you have many times, and that gives us the credibility with the insurance companies.
For sure.
Yeah, so that there's an ability to negotiate the best settlement possible in those situations.
Exactly. So let me back up, because I don't think people realize the importance of what you just said as far as being board certified. So we're not going to just gloss over that. That's a big deal. I've mentioned it before on the air that yourself and Brian Caulfield at our office are both board certified trial lawyers. So for the public, because most people may not even know what that means or how you can obtain it, can you tell us a little bit about what it means to be board certified and how you can achieve that as a lawyer?
Sure. So obviously, anyone that becomes a lawyer takes the bar exam and is approved by the Florida Bar after they've passed a review to practice law in the state of Florida. But you also have the opportunity in different specialty areas, and there are quite a number of different ones, but civil trial is the one that applies in our area, to qualify for a certification by the bar that says that you are a specialist in that particular field. And what's involved is you have to have practiced law for at least 5 years, and then you actually take a test, another additional bar type exam, and have to pass that. And then there are certain character references and that sort of thing. And you have to, most importantly, you have to be able to show and demonstrate. You go back through the cases that you've tried, and then you have to establish that you've met the criteria for the number of trials. At the time I was going through that process, I think it's still the same. You have to have at least 15 actual trials that you were involved in a major way, and several that you were actually the lead counsel in.
Right.
And then after completing those requirements, then the bar will certify you as a certified civil trial lawyer. That is a certification that lasts for 5 years.
Right.
And then you have to renew it by basically updating through continuing legal education. You also have to show that you've had at least 2 additional civil trials and additional character references and that sort of thing. So,
Sure.
so every 5 years it's renewed. So I was first certified in 2001. So every
Wow.
5 years since that time,
You've maintained
I've
it.
maintained that certification, and it's been, renewed. And
No small feat. That's pretty impressive, because I don't think people realize how hard it is sometimes to get your trials and to actually have it go all the way.
Yes, I think that, what has happened over a long period of time now. I mean, I've practiced law for a very long time, and there are a lot of reasons that it becomes difficult for people to get the trial experience. As it becomes more and more expensive for trials to be presented,
Sure.
there were fewer trials occur, and so it is. As I said a moment ago, I mean, obviously most individuals would hope they wouldn't have to go through that process, but
Right. I think people come in hoping that it'll resolve and it goes away and I never have to see the inside of a courtroom.
Exactly. But for those of us that love the law, love debate, love the trial part of it, and also know the importance of being able to perform that function well, the certification process is really an important and helpful one. Very small percentage of lawyers actually do have that certification.
You anticipated my next question.
I think it's like 1% or something.
Yeah, not 2 or 3%. It's very small.
Very small.
And that's a big distinction, which is why I really wanted you to talk about it some more, because what you're listening to is the fact that not only is it difficult to get cases all the way to trial, but then to also be certified and then be recertified every 5 years.
And I'm not even going to do the math.
Yeah. So that's a really high distinction and accomplishment. So kudos to you for that.
Well, and I'm very grateful to be at our law firm, which allowed me to do that.
Exactly.
Basically.
Exactly.
Very, very grateful.
We do try cases, and it's necessary to litigate. And as you mentioned, not everything always goes to trial. So I do want to kind of back up and let's take the road as to how you end up there, because trial is kind of the end game. That's when, all else has kind of failed throughout the litigation process and you end up in front of a jury. So I guess let's start from the beginning, and let's say we have some sort of an injury claim, whether it be an auto accident, slip and fall, medical malpractice, whatever the facts may be, it occurs. Now, should I call a lawyer right away? When is it appropriate to contact an attorney after this event?
I'm going to tell you, after a little bit of personal experience last year, that it's a good idea if you have any type of significant injury, anything that is more than minor and obviously going away, and you're in a motor vehicle accident, you should contact an attorney.
Exactly.
There's a tendency not to want to do that. And, I'm going to say, do as I say, not as I do. Last year I had, a relatively minor rear end collision, and
Sure.
I've been blessed, frankly, to avoid that.
Right.
But I had a friend with me.
That's amazing. In Florida and Tampa Bay,
Oh,
to have been gone that long without an accident.
But one of the things that I noticed, because, obviously, because of the kind of work we do, if something happens, you start thinking, oh, wow, boy, I can really relate to what my clients are going through.
Exactly.
And so in that scenario, fortunately, it was not terrible, but it was a $5,000 or $6,000 repair job to
Sure.
the rear of my vehicle. And I had a friend who was with me who was a little bit older, and she had pre-existing issues in the
Right.
past. And so it was a little bit more of a thing for her.
Sure.
But even for me, I actually found that the way I was holding the steering wheel, I kind of clenched it, and I didn't realize, but by the next day I was feeling something in my my hand. And I frankly, honestly think I may have fractured the knuckle or something, because I did my own, Google research. But now,
Dr. Google.
now I'm going to say that, fortunately, I didn't have anything that was an ongoing issue. But if I were advising someone, as Matt did advise me, oh, Lori, go at least, be checked out, get an X-ray or something. And that's important. And it's important to get that advice, because as we know, in Florida, under your auto insurance, if you don't go within 14 days to see somebody, then you're not going to be able to have your bills paid under your automobile insurance, your PIP at least.
Right. And that's something that you pay for every month or every 6 months, however you pay your premiums, and you're losing that benefit,
But regardless, in that situation, if I had been representing me, I would have, if you communicate with a lawyer about what's happened, when it's clearly, if it's something that you have no problems whatsoever, no injuries, obviously, then you don't need to speak to a personal injury attorney. But the thing about injury is that it is something that can be progressive. Exactly. And so just that small thing I'm describing in my hand actually did progress. I mean, I didn't think it was anything, so it's the kind of thing you need to be alert to instead of saying, man, I don't want to deal with it.
Right.
It's better to get a little advice on that because in the event, had I ended up with a more significant issue, then it would have been important to have followed up medically right away. Now, I'm thankful, obviously it turned out all right, but you really don't know in the initial stages, the way the body works, it can take a few days to know what you're dealing with, and even sometimes a little bit longer than that. Right. So good idea to call right away, really.
And there's really no downside to reaching out and discussing it with us as a personal injury attorneys. We work on a contingency fee basis. So when you come in, you're not going to be charged for a consultation. There's no retainer fee that you have to put down just to come in and discuss your injury claim with us. So even if you're not sure of what your rights are, how long you have to get treatment, should I go get checked out or not, it does not hurt to just come in and speak with us, and we can kind of give you some guidance. And then, of course, you can decide at that point how you want to proceed. But I would not delay, exactly like you said, Lori, at all.
And we talk with people all the time to just to give informal advice, just so calling, get it reviewed, and then, you have a better idea of how to handle the situation.
Exactly. And so that's a good segue into, when we're giving that advice and we're representing someone after the contracts are now signed, kind of give our listeners a little bit of a preview of coming attractions, if you will.
Well, and one thing before I get to that I think I want to mention, the other thing that does happen rather often is insurance companies go to people who think they have had, who think they have had a relatively minor situation. They say, let me pay you a couple $1,000s,
Oh, there's some that's notorious for that. I won't name the carrier, but we know.
And the truth is, it's just, you really should never enter into something like that without having a conversation with an attorney.
Yeah, exactly.
Because it's not to your interest. But let's say, okay, you've come to the lawyer, we've reviewed the case, we review the nature of the contract, which, as you say, is in this area of law, it's a contingency, so the person doesn't have to worry about paying anything, not a dime, for the consultation or anything.
Exactly.
If there's a recovery at the end of the case, then the fee is a percentage of that. Yeah. And that's all, of course, reviewed at the time of the consultation. But after the contract is signed, we open up a file. Where does it go from there? It's the initial investigation. The person's going to have to follow up and get their medical treatment.
Right.
First goal is obviously
treatment.
That's right.
So key.
Obviously, the hope is that the person can do better, but the importance from the lawyer's point of view of needing to show evidence of what's going on is that the individual is following up with the doctor, telling the doctor what the issues are so they can be addressed, but also so they're documented in the medical records.
Exactly. Yeah. And that's what I think a lot of people don't necessarily understand. They're like, but I'm in pain and I'm hurting, and I feel like they should understand that. And it's like, well, how do we prove it? Other than your argument or my argument or your statements, how do we prove that? And that's medical treatment, medical documentation, seeing the doctors, being consistent, being compliant. Nursing yourself at home, is not going to give you the evidence you need if we go to trial. And that is, of course, what we're leading up to. But we're I feel like I have to stress that to so many different clients, and that not that they're not hurt.
Right.
They just, like yourself, you're busy, you had a car accident and your wrist started bothering you, but I'm sure you had a ton of other things you needed to do.
Absolutely.
And it's hard to make those appointments and take that time aside to do those things.
And I think what, does happen, and I did what I think almost everybody does today. I did my own Google research. Then I kind of scared myself, but not enough to do anything about it, right? But yes, so it is the other thing that's important, not even just from the evidentiary point of view, but honestly, for a person's best chance to get better, treatment early and consistently.
Exactly.
And that's the goal, is to get better. We are simply, as lawyers, trying to preserve your rights and be sure that you get the benefit of everything you're entitled to. You pay for auto insurance because it's mandatory, so that PIP will pay 80% of your bills up to $10,000.
Exactly.
It's gotten a little tricky, but that's simple understanding there. So you can get the medical care, and you should take advantage of that, so that hopefully you have the best chance to get better. But if you are left with some residual issues or ongoing issues, then that's what becomes the basis for your actual claim against the at-fault party, the person that caused the accident.
Right.
And that's really what is at issue here. So in that early period, we're going to do investigation about the facts and circumstances of the accident, send an investigator out to take pictures and talk to witnesses, and determine what the insurance coverage is, because that becomes a very important factor in what can be obtained in terms of a financial recovery to compensate you for your losses.
Exactly.
Unfortunately, in Florida, we have a mandatory insurance, but it's really geared just towards that PIP and the property damage.
Right. A lot of people don't realize that. Matt and I touched on that last week, that people assume I'm fully covered. I've got full coverage. But what does that mean in the state of Florida, right, Lori?
It means full coverage as required by law, which means if that's all you've got, you do not have anywhere near really full coverage.
Exactly.
Because in that scenario, so you said you discussed it last week, but it is something we find people
we can touch on it again.
They just don't realize that you're relying, if you have something happen, like, for example, the accident I was in, sad to say, the person that caused it, I was at a railroad crossing, and there was a car right behind me, a big Mercedes, and then the car that caused the accident was the car behind that wasn't paying attention, and the lady just slammed into that Mercedes, which slammed into my car.
Right.
The lady that caused the accident, she didn't have any insurance. And
we see that way too frequently.
And so in that scenario, if I had ongoing issues myself, I do have uninsured motorists, so I would have been able to bring a claim because I have insurance that's intended to cover for that. So, and the driver behind me had no responsibility. That poor fellow was just in the middle of the Oreo cookie, so to speak. There's nothing that he could do. He wasn't at fault. And so obviously we can only bring a claim against someone who's negligent and has actually not been careful and is responsible for causing the accident.
So after the investigation phase and we figure out, what the insurance, available insurance is and who the at-fault parties are, where the negligence lies, what typically are the next steps after that? Okay.
So a couple of things that will have happened in that early period.
By the way, Matt said, great show.
Oh, there you go.
He's on the road to Fort Myers.
Well, we have a few people planted along the way, right? We're glad, and we do hope that CCC wins.
Exactly.
So part of what will happen in that earlier period, the insurance company early on is going to want to take your statement, and that's something that we would be a participant in. So after the initial information is together, then really what's happening is the person is going to treat. And typically it will depend on the nature of the injury, but it's probably going to take several months, 6 months, something perhaps longer, for the person to have the benefit of all the treatment that may be necessary, and then to reach what's called maximum medical improvement, which is once you're at the point where the doctor says, I'm sorry, but this is kind of where you're at, and they can give you some PRN helpful care to go forward with. Maybe you'll have chiropractic to help, massage therapy, but basically they can't do anything more in that scenario. At that point in time, your doctors will indicate, if you are not 100% recovered, that you do have some degree of permanent impairment or injury as a result of the accident. And in that situation, we can then make a actual settlement demand claim against the at-fault party, the person that caused it, against their insurance.
Right.
And that would be the next part of the process, in which we hope in many cases can be resolved at that part of the process.
That's usually what we try to achieve, but we know that it does not always go that way, right?
Those insurance companies are hard to deal with. And they don't like to give out money, basically. And some of them are harder to deal with than others. So,
exactly.
Yeah. So what ends up happening is if you get to a place where the insurance company is just not reasonable after a series of negotiations, which the way that would normally work is, we would make a recommendation for a settlement demand that would be communicated to the insurance adjuster handling the case for the person that's responsible for the accident. You go back and forth with negotiations, which we would be discussing with the client and obviously giving them advice and getting their authority to make any settlement offers.
Right.
And then hopefully the case can be resolved. But if it cannot, if the insurance company is not reasonable, as is not uncommon, then the next step is to file a lawsuit. And so at that point,
here we are. Dun, dun, dun.
Yes. So, that's something that is discussed carefully with the client because a lawsuit is a lengthy process typically.
Exactly.
Once you file the lawsuit and the defendant, the person that caused the accident, has to be officially served with a summons, and then the lawyers for the insurance company defend that person.
Correct.
You go through quite a lot of activity that the client, the person that's been injured, is going to have to be involved in. And a lot of times it feels like something the person would prefer not to be involved in.
Sure.
But you have a right to be treated fairly and to have the benefit of the rights that the law guarantees you when you are injured as a result of somebody's negligence. So,
exactly.
So we'll do what they call discovery, which is where we'll make requests to get documents from them. The insurance company will typically want medical records from the plaintiff or our client, the person that was injured.
Right.
There'll be depositions, which is a formal statement where the attorney for the insurance company has an opportunity to question the client, which obviously we prepare for and are there, right there with the person. We will take depositions. We may, if there's a dispute, if it's a simple rear end collision, not any real issue about the liability. But say it's commonly, you might have a left turn situation, very common at an intersection, and somebody tries to beat the car, and there's a little bit of an argument potentially about who's at fault.
Right.
Then we might take a deposition of the people, the witnesses, and the people that were involved there. So already you can tell it's like there's a lot of stuff going on.
It is.
A
lot of things the client themselves may not be involved in,
and they're probably happy. As I'm saying all of this, I'm thinking anybody would be thinking, "Oh man,
this is
I don't know if I want to do that." Yeah, most of that is really the lawyers doing that.
Exactly.
There's some simple written questions that we assist the client with that have to be provided typically during the process. But probably the most significant event would be the deposition for the client. That's and that's kind of a good opportunity because actually it allows the defense lawyer to see the person as a real person, not just a file.
Absolutely.
To begin to get an idea of what would it be like to have to try a case against this nice person. And often they're going to conclude, maybe we'll talk to the insurance adjuster about what we could do to get this one resolved.
Absolutely. And that's a great point because I had several cases where the defense lawyer left the deposition and just said, that's a likable person. I like your client. I think they present really well, and I'm going to see what I can do to get this resolved. And I think when they leave with a good impression of the client, who's the plaintiff, they realize if we take this all the way to trial, jury's going to probably feel the same way I feel. This is a good person, that this person has been through a lot. They're credible, and you're going to be sympathetic to what they've been through. And
absolutely.
I think if you are well prepared for your deposition, that's easily conveyable.
Yes. Now, there can be things that are challenging along the way.
Of course.
A lot of people will...
Litigation is not without challenges.
It makes it interesting, because, if it was a simple, easy case and there's no such thing,
right.
those cases would get resolved. So there's always going to be some argument, like people will the insurance industry just can't believe anybody can be injured in an accident in which there's not a lot of visible damage to the vehicle.
Yeah.
Even though every single one of us in our personal lives know that you absolutely can be injured.
Absolutely.
Fortunately, many times, maybe most times, you can walk away from an accident. It's no big deal, but there's a high percentage of times when that isn't the case. Even though if you were to look at the car, you wouldn't necessarily be able to tell that.
Right.
So you get fought hard on things like that, but the individual should not give up in that setting. I would say, because the truth is, it's absolutely medically clear that people can be injured because the forces involved in a car accident are such that it depends on many different variables.
Exactly.
The other variable that often we see are people that have had pre-existing injuries.
Sure.
And if you've been alive on the planet for any length of time at all, good chance, that you're going to have had some degree of issue in the past. That doesn't mean that if you are injured in an accident and made worse and it doesn't go away, you have an absolute right to recover damages for what you've experienced.
So I think I just want to reiterate what Lori said before we take a quick break. If you have an accident, don't count yourself out for reasons that you think, well, there really wasn't any damage to my car. The other vehicle barely had a scratch. I don't think it's worth pursuing. My back has been bad for years. It feels worse, but I've been seeing somebody for my back forever. And you count yourself out. You should never, ever do that. I think if you notice a difference, if you notice pain, regardless of what the vehicles look like, regardless of what your history is, you should still contact a lawyer, as we said before, discuss your options and figure out what your rights are, right? So I think that's a good place for us to take a quick break. The lines are open, folks. The number is 727-441-3000. We are here with Lori Robinson, who's talking about trial litigation, and she's here to answer your questions as well. We're also on Facebook, and drop your comments there. We'll be back soon after the quick break.
This is the TAN Talk Radio Network.
In 1955, the law firm now known as Pernick, Caulfield, Averill, and Noyes made a decision. Instead of taking whatever cases came through their doors, they decided to focus specifically on personal injury. 64 years later, the law firm is one of Clearwater's longest-running personal injury firms. Available 24 hours a day with offices in Clearwater and throughout Tampa Bay, they're ready to put decades of experience to work for you if you or a loved one has been injured in a car accident or injured due to someone's negligence or recklessness. If you feel overwhelmed, uncertain, or unsure about your next steps after being involved in an accident or after a loved one sustained serious injuries due to someone else's negligence, call Pernick, Caulfield, Averill, and Noyes at 727-796-8282 or online at usalaw.com. That's 727-796-8282 or online at usalaw.com. Non-attorney spokesman.
This is the TAN Talk Radio Network.
On the air with FLA Law. I am still here with my wonderful guest and co-host, Lori Robinson. She's been talking to us for the past few minutes, talking about trial and litigation. In case you missed it in the beginning of the show, she told us that she's a board-certified civil trial lawyer. She's been with our firm, Pernick, Caulfield, Averill, Noyes, for almost 20 years now, maybe over 20 years. I don't know. I don't want to age her.
No.
But she's very seasoned. That's what we'll call it. And she of course, is a great asset to this firm, and she's just been giving us some really good advice and information on what to expect if you find yourself in a civil litigation matter and a personal injury claim, and how that process is going to kind of work its way through the claims into the court system. So before the break, I think we were just kind of touching on the deposition process and how that's obviously something that's going to be a part of it, where the defense lawyer gets to sit the plaintiff down and ask them questions and get to know them and hear their story, and how this accident has impacted their life. Of course, there's always going to be some issues that can arise. Like we said, litigation is not without, its issues. So with that being said, after the depositions and the discovery, what comes next, Lori?
So after that part of the process, the next thing that happens is mediation. And that's really, when we're in litigation, that's really our focus, is to get to mediation, which is a settlement conference that is handled with a mediator who is a lawyer or judge who's been certified to do that and kind of facilitate settlement discussions. And so it's like a conference.
Exactly. And if you've been watching the show and listening past couple of weeks, we had a circuit civil mediator on the show a couple of weeks ago. So if you got to hear that show, then you know all about mediation.
And mediation is great. I mean, it's existed all the time. I've been practicing law. Apparently it didn't before, but it focuses everybody in on that case at that time. And it's not the only time a case can settle, but it is one of the best times.
It is, right.
And so I would say a very high percentage of cases in litigation are going to settle at the mediation.
Right.
Small number will not. And then those cases go into a category of getting set for a trial date. Yeah. And, typically, especially now after the COVID situation, there's quite a backlog. So it does take quite a while to get your case set for trial. But we will typically tell people to expect litigation to be a couple-year process. If we can get to mediation, in a year, but unfortunately, it does take a while.
And people are quite shocked by that, by the time frame. They don't really realize how long it kind of takes the case to work through the process and to get in front of a jury.
Yes, and it's really outside. Most of it's outside of our control, really. It's so in litigation, you're dealing with a court docket, and so after mediation, again, you get that trial date. Most cases will settle sometime between mediation and arriving at the courthouse steps, so to speak.
Yes.
But a small percentage will not. And in those situations, you're actually going to go into a jury trial. And if you're in that situation, you're going to have spent a lot of time with your lawyers. You're going to be totally prepared. You're going to feel that it is the right thing, the best thing to do. So no one is going into a trial that doesn't have that sort of understanding.
Exactly.
And then trials, they're our typical trial, I would say, if you want to, each case is going to be different.
Right.
But typically you're going to expect a trial to take 2 to 3 to 4 to maybe 5 days.
Right.
And that involves.
And you, as the client or the plaintiff, you do have to be there all 5 days.
Yes.
Or however long the trial goes.
Oh, yes. Yes. I mean,
so typically you were kind of hands off as the client, right? Throughout the litigation process. You're not necessarily there.
Right.
But once you get to trial, you're there every day.
Yeah. So, before that, you would have appeared for your deposition.
Right.
Your mediation. And that would be
That's about it.
That would be it. So it's not, although it's a little bit involving, but it's not that bad. Trial is certainly something that most people will perceive as, a little bit of a stressful event.
It is.
But
even for the attorneys.
Oh, yes. It's very, it's exciting, but it obviously is an intense experience.
Right.
And, but it is important to always be prepared and willing to go to that step if that is what is necessary to achieve some semblance of justice in your situation.
Exactly.
And by justice, what I think of it as is getting the best result possible under the circumstances.
Right.
We unfortunately can never roll back time, which is what we'd really love to be able to do, and just avoid that whole accident to begin with.
Exactly.
That would be great.
That would be ideal.
That would be ideal. So all that our system can provide is monetary compensation, and there are a lot of factors that go into what is possible in a given situation. But ultimately, if your case goes to a jury trial, the 6 people on that jury are going to decide.
Right. And so it does, at that point, it's kind of out of the lawyer's hand. The lawyer does the best possible job they can to present the facts and the evidence in the light most favorable to their client. But then once it goes to the jury, it's out of their hands. And we can only hope that we've done the best job in conveying our client's story to the jury.
Right. Yeah. And generally speaking, jurors are as different as the driver's license rolls, et cetera, that they come from. So you never really know.
You don't know
who it's going to be. Yeah. And so there are a lot of factors that go into the process of selecting a jury and all of those aspects of it. But, as I say, very few people will undergo that experience, but it is something that is the bedrock of our civil justice system.
Exactly.
And so we have 7th Amendment, U.S. Constitution, right to a trial by jury in a civil case. And
I'm curious, just from your own perspective and insight, I've heard different things from different lawyers. Some lawyers say that jury selection is the most important part of the trial. I've heard some people say that, after the openings, the jury already has their mind made up. Do you have any thoughts on that?
Those are kind of bits of conventional wisdom, but I do believe that the jury selection actually is the most important part of the case. It's really, in state court, we're fortunate because we can have a fair amount, although it's still, the court does try to limit you in how much time you can take, but you have a fair amount of opportunity to ask questions of the prospective jurors and try to get an idea of who to weed out.
Right.
But you're limited because you only have a certain number of what they call peremptory challenges.
Exactly.
Unless you can show that there's actually good cause that a person would not be able to sit fairly. So, so you do the best you can to get the best jury you can. But obviously, people's attitudes and experiences have a great deal to do with how they'll decide. In my long career, I've really felt that juries, generally speaking, work very hard to do the right thing. But it is a risky process for both sides, for the defense as well.
Right, equally. So. I think that obviously brings us to the trial, and the jury gets the case, and they come back with a verdict. The verdict is either in your favor or not. Is that the end of it? What can happen after that? And
although usually it's in your favor or not, you can get a hung jury in a civil case.
That is true.
Matt and I,
great point.
We had that happen, which it's not common at all.
It isn't.
Really.
Yeah.
It's like the jury couldn't decide.
They just can't decide.
It's like, but that's unusual. But once the case has had a result of a verdict, then the parties have an opportunity to appeal if there was some legal error that they felt they could pursue into the appellate court.
Sure.
But you can see now we're talking years.
Exactly.
Years. And so usually cases resolve, basically at that point, but not always. And of course, it's going to depend when you talk about a very large case involving very significant damages. That is in a different ball game, and in that case, such as that, might well need to go through the appellate process.
Right.
But those are all very, very individual things.
Right. And so obviously, as a listener, if you're listening, your case is going to be individual and specific to you. So we can't, of course, predict how things would go if you were to find yourself in that position. But this does give you some good insight, I think, into what you could expect. I think that's a really good summary that Lori has given us as far as from beginning to end, how it starts and how it can potentially end. So that's been excellent, Lori. I want to, of course, remind our listeners, we've got a little bit more time here on the air. So if you have any questions, anything that Lori has mentioned that might apply to you or you have questions about, we are still taking your calls at 441-3000. The lines are open. Again, that's 727-441-3000. We're also on YouTube and Facebook, so feel free to stream from there, drop your comments in the chat box, and we will answer those live on the air. That, I think, has been a great summary, Lori, of the litigation and trial process. But we've touched on it before, but I think it's a good idea to kind of talk a little bit about it more, because I think we do a public service by doing these radio show and informing the public about what's going on in the law and what changes have occurred here recently in the legislature that impacts you, the everyday person, every Floridian, really, who may end up being injured or hurt now since I believe it was March 24th or 25th, somewhere around there. The law has changed pretty significantly. And so
in many different areas.
Yeah. And so I think it's good to kind of talk about it again and make sure people understand how their rights may be affected by this new change. So feel free to jump in. There's so many areas that have been impacted: comparative fault, the way the law looks at the medical bills. So
it's a complicated, convoluted series of changes.
Rushed through very quickly.
Oh, yes. But I did think a couple of things. One I want to say is one of the things I love about our firm is that we are there to represent people. And if it could be a small case, it could be a medium-sized case, it could be a big case.
Exactly. We
are there to represent people that have been injured. And so people should be encouraged. If you've heard things and just want to give a call to the office later on or something, if you have a question, I hope it's not overwhelming to you as I describe the whole process here, but it's my life and I love it. One of the most,
and we can talk about it for hours.
Yes, we can. One of the most significant changes, and this might actually be a positive in the long run, is they've changed the statute of limitations to 2 years.
Correct.
So where currently it used to be, prior to March 24 this year, that if you had an automobile accident or any type of, actually any way that you were injured as a result of negligence, if you slipped and fell somewhere, then you would have 4 years from the time of that accident in which to bring a legal claim. And we call that the statute of limitations. Well, that has been changed. So as of now, if something has happened, if you're in a motor vehicle accident now, you have 2 years. And that means it's even more important to be talking to an attorney and getting some advice on your situation as quickly as possible, because 2 years isn't actually a long period of time.
It's really not. It goes by very quickly.
All right. So that I think is something, it's been 4 years for so long, I'm going to have to drill that into my head.
Yeah,
I can't even imagine.
Even now, as you were saying that, I'm just thinking about cases that have come in recently. I'm like, oh my gosh, we've only got 2 years.
Right. And of course, people will think, well, that seems like a long time. But no, it's not really.
Not.
But that's a very significant one. And there's some kind of complicated things that have happened related to medical bills. I think that would be a little difficult to, it's kind of probably inside baseball to even talk about. The main thing is, a lot of times people will come to the lawyer and they don't really know which doctor to go see, and a lot of times your family practitioner doesn't want to get involved in anything that
they don't take the PIP.
Yeah, they don't want to get involved with all those insurance requirements and that sort of thing. And so those are situations where it's not uncommon for lawyers to make recommendations or referrals. The law has made that a little bit trickier, but not in terms of getting some input from your lawyer, really, as to some advice on that.
Right.
The other thing that's happened is a change in what we call comparative negligence. Again, that's probably kind of inside baseball. See, now, if Matt, he's probably out of the area where he can hear us, but since he loves baseball so much, he'd like that.
You got to make
metaphor.
the reference, yeah.
But anyway, but there are certain things like when you slip and fall or have some injury happen because somebody hasn't kept a business flooring safe or this kind of thing. There are types of areas where we consider whether the person could have had some responsibility, and the law has changed there so that if there's a finding that person was more than 50% responsible, then they would not be able to bring a claim. Now, I'm going to say honestly that I don't believe the claims you're bringing are going to be situations where where we don't believe that's the case.
Claim, we typically don't believe that our client is more than 51% responsible.
I would advise the prospective client to let the lawyer consider the facts and make that determination, because a lot of times, people will feel almost embarrassed or whatever, and they we're all our own biggest critics in many respects, you know. So
Right.
yeah, it's always good to get an evaluation. But so there's some things like that have been changes, and many others. Actually, it was a very, very lengthy bill, and like you said, it was rushed through, and that's kind of unfortunate, probably. But having practiced law for as many years as I've admitted to now, you know what? We'll get through it just fine, you know, basically.
Yeah, I feel like, I mean, although this is a very massive, I think, tort reform bill in terms of the changes that it made, it's not the first time this has occurred. And so over the years, you know, we've had to deal with legislation that has come out and unfortunately limits the rights of, you know, the injured in the state of Florida, but we address it, we pivot, and we do what we can
we're
as
still
advocates.
Here fighting.
That's our job, to be zealous advocates for our clients, and we will work with the law. We get, you know, creative. We do what we can to fight for our clients. And as you said, I think we just kind of roll with the punches, take it on the chin, and keep it going.
Absolutely.
So,
Absolutely.
but yeah, I think a lot of people, like you said, shouldn't just count themselves out. They think, oh, well, now the law is different. If I'm 51% or more at fault, I may not even have a claim, so I won't even call a lawyer. That is the wrong mentality to have. Could it present challenges? And depending on the facts of your case, it might. But let us, as the attorneys, make that call for you. Don't fail to, you know, figure out what rights you may have by not even calling.
Right.
You know, so I think that is something that we definitely want to stress. Could it be a more challenging thing here moving forward? I think maybe insurance companies may not, you know, be as willing to resolve certain claims as they probably would have before the law changed. But it doesn't mean that we can't take those cases to trial.
And we're all prepared,
Exactly.
as we've discussed this evening.
Exactly. So any other thoughts on the new law? Obviously, we referred to it before as House Bill 837, but it is now a statute. And
it's affected a lot of different ones. You know, when I printed it out before I came over this evening. And there are many different things. I mean, they made it more difficult to recover attorneys' fees, in insurance disputes, which is bad because that means it's harder to get a lawyer to help you on maybe a smaller thing and in dispute. But again, Pernick and Carroll, that was the original name of the firm. Pernick, Caulfield, Averill, and Noyes had its founding in 1955. You know, Guy Pernick literally started one of the first, and we believe probably the first in the Tampa Bay area that specialized in personal injury. So God rest his soul, he's gone on. But I know he could tell us about a few changes over the years.
I'm sure, exactly. And that's exactly right. I mean, we've kind of seen it all and dealt with it all. We, take it as it changes, and we just keep on trucking, and we're going to keep fighting for our clients. And so that's a great point that you made. We've been around so long that we've kind of seen it all. We've got the wealth of knowledge and experience to address a lot of those issues as they come up. So if you have questions about the change in the law, or you're not sure how it impacts your case, you've had an accident since the law has changed, definitely give us a call. I'm going to give you the office line because we're getting ready to wrap up. But if you have any questions after we get off the air, the number is 727-796-8282. That's how you reach us at the office. As I said, we're Pernick, Caulfield, Averill, and Noyes injury lawyers. If you want to look us up online, our website is usalaw.com. Lori, it's been a pleasure having you tonight. As we said, we can talk on and on about these topics, but the time just really flies. Is there any parting words or anything you'd like to say to our audience before we head off the air tonight?
Just never give up. We're here for you, and please feel free to call us at any time and let us give you some help.
Absolutely. And that's our show, folks. It is FLA Live on the radio. We will see you next Tuesday at 5:00 on your drive home. Whatever you're doing, we will be here in the studio. As I said last week, it may not be me, but one of the attorneys will be here hosting the show, and I'm sure you'll have a great show next week, next Tuesday at 5. We'll see you then. Good night.